I'm going scriptless again. Not legal advice. Like, subscribe, share, comment, send money, send food, whatever you'd like. Send a car. I'd like a Tesla Plaid if anybody wants to send it to me. Feel free. We can make arrangements. Anyway, hope everybody is well. Good Friday morning. I kind of wanted to do something I wasn't planning on, but I figured it would be interesting because others might be able to use this information in their own arbitrations or otherwise. But before I get into that, I just burned 2,000 calories. That's the last time I'm going to leave the brownies in the oven while I nap. Anyway, so as you know, I'm involved in an arbitration with Fidelity, and I have been sparring with my opposing counsel to this point in time. It's a large law firm that does this kind of work. So, as you know, I filed a arbitration claim, and we're going back and forth over various issues. One of them I was concerned about was the answer that the counsel for Fidelity, the defendant, we'll call them bad guys for this particular video, they kind of belittled the naked shorting claim and the existence. They attached a copy of the loony article that we saw a while back. I then responded. I thought that opposing counsel was trying to poison the arbiter pool, and that we need the. And then what happens is they send out a prospective list of arbitrators, and they show what cases they've handled, et cetera, but they don't give you specific understanding of what their basic philosophy is. And counsel for Fidelity was making an issue of naked shorting and was belittling it and suggesting it really didn't exist. So as a result, I made a demand on Finra and opposing counsel, which opposing counsel objected to and filed an objection. I asked Finra, I said, in light of the accusations, besides I wanted the answer stricken, which we haven't gotten to yet, and that particular matter stricken, I wanted each arbiter to now disclose what their position, if they believed or didn't believe in naked shorting or counterfeiting, and if they were aware of it, and if they were not aware of it, would they have an open mind to consider that? And apparently, Finra agreed with me. So I have received now about 20, there's a big list of arbiters. I've received a bunch of replies to that specific issue, counter to the way Fidelity would like to have done it. So now we will have a record of these arbiters' position or lack thereof as to naked shorting, which will permit us to make better decisions on which arbiters we end up choosing. It also opens the door, in my opinion, when issues arise and maybe your opposing counsel, and this is directed not only to MMTLP, GTII, the plaintiffs, but their attorneys. So if you see opposing counsel take a position that's belittling of your position, you can kind of now focus on that with the prospective arbiters. For example, in my case, I think now, since every arbiter now has been focused on naked shorting, they will become more aware of it and have a better understanding of it. And I think it's going to give us a better chance of prevailing in arbitrations. So if you're in, and I'm not telling anybody what to do, by the way, this is just me talking out loud based upon my current experience. But if there's other issues that arise in your dealings with an arbitration, based upon what your opposing counsel is, I think you should be aggressive and approach FINRA and make them, the arbiters, sign off on those issues. And if they don't, you could obviously cite to my case as an example where opposing counsel has created an issue that might poison the arbiter pool. FINRA has agreed to basically poll the prospective arbiters. And that's directly contrary to what defense counsel argued. So I think it opens the door in FINRA arbitrations. There may be other issues where I where I make the same request. Right now, I put in a motion for discovery. The defendant's counsel has put in an opposition. I'll reply, and we'll see what happens. I wouldn't be surprised if, well, I don't know. We'll have to see what happens because we don't even have an arbitration panel yet. When we get there, I'll address that. But anyway, just wanted to let you know that Finra has responded in a positive way to my request, and I think it opens the door in future arbitrations with other people to kind of focus the arbiters on the issues that we want them to focus on and to get a better and fairer arbitration pool. So, since I found it out today, being Friday, I wanted to pass it on. And anyway, everybody else, have a great holiday. Be well. Take care. And my next live stream with Mr. Tiny JR will be Tuesday night. So we'll see you then. Take care. Be well. Have a great holiday.